Please give us a brief introduction.
Good evening, sir. My name is Irsheeta. I'm a resident of Gadpos village, which falls under Sambalpur district. And I have graduated in BA LLB from National Law University of Study and Research in Law in 2019. And since then, I have been preparing for judiciary. And my hobbies include to watch movies, singing, and listening songs.
Okay, fine. So, did you take any special paper in your graduation?
Yes, so I had honors in IPR, Intellectual Property Rights.
Intellectual property rights. Okay. So, and did you participate in any like moot court competitions or any advocacy competitions?
No, so I did not participate, but moot court was compulsory in our college. So this was a part of our syllabus. But outside college, I did not participate in any kind of competition.
Okay, okay, fine. So, your your special paper was on intellectual property rights, right? So, uh,
Yes, sir.
can you just differentiate between a patent and a copyright? Although it's not a part of your OJS syllabus, but still then, since it is a special paper, if I'm a layman, I don't understand anything about this intellectual property. How will you differentiate between a patent and a copyright?
So both patent and copyright form part of intellectual property rights. Both are protected under this particular right.
Mhm.
Whereas patent applies on innovation. Suppose a person has invented something, it is new, it is novel, it has an industrial application. Any scientific discovery or any scientific invention that a person does is protected under patent. But copyright is not something which is related to machines or inventions. Copyright is the protection of ideas, ideas in artistic way, ideas in literature way. Whatever ideas, new ideas that you have, you can get it copyright. And whatever invention that you do, you can get a patent of it. For example, inventions may be for example, so the invention of polio vaccine, it could have gotten patented, but it was not the scientists did not get wanted it to be patent, so it did not get patent, but it was eligible to be get patent. But copyright, for example, a movie, a script of a movie, or any script of a TV show, that can get copyright protection.
Mhm. Okay. So, copyright, especially patent, is such a growing field from the legal side. So, if that was a special paper, why are you not interested in joining the legal firms which deal with patent related, disputes and all? That the amount of money is also significant. What is the reason
Yes.
you are interested in judicial services where comparatively maybe your salary will be very less?
Yes, sir. I'm aware of that. Even when I was joining, even when I took IPR as my honors, I was aware of this fact. But it was not my intention to get in any form. I did not. I haven't done anything since 2019. Since the day I graduated, I have been focusing on judiciary ever since. And it was not my intention even when I got into college. Since I joined my college, I had the intention to go for judiciary, and I took IPR because other specifications or other honors papers were not very much lucrative for me, because there was constitution which I had already studied, there was criminal law which I had already studied, there was, I think, there was business law in which I am not at all interested. So other honors were not as lucrative as IPR, and I thought I would gain an additional knowledge. So that's why I joined IPR. That's why I took IPR as my honors. But since the first day I joined college, or even before that, I had only and only judiciary in my mind and nothing else.
Okay. This is your which attempt in Odisha Judicial Service?
So this is my first attempt.
This is your first attempt. Okay. And first attempt you have got the
Yes, sir.
interview call. Quite good. Okay, fine. So, you, under which university you have passed your LLB, you said?
So National University of Study and Research in Law. It's in Ranchi.
Mhm. Just some jurist, major legal eagle. Basically, I think 5 6 years ago he gave a statement that the national law universities are turning out to be islands of knowledge. Do you know what he was talking about?
No,
Islands
sir.
of knowledge. Okay.
No, sir.
Basically, what he was talking about is that after passing for there, it's like, you know, they are not connected with the what is happening in the grassroots of the legal side. Very few are joining as advocates. Okay, they are actually most of them are going in other dimensions, maybe corporate or maybe as consultants. Okay, that is what he was trying to say. What is your opinion on that? Suppose you take a sample size of your batch, so how many have joined as
Yes,
how
sir.
many joined as advocates, or how many are interested in uh, judicial service, and how many are interested to join a law firm or to start their own law firm? Okay.
So, as this statement was made, as you said, this statement was made around 5 6 years ago. So,
Mhm.
I would have totally agreed with this statement if this question, if this statement was said, if I heard this statement 5 6 years ago, because I joined my college around six. I was the first fifth batch in my college, and I saw many seniors of mine, like the first, second, third batch. Many seniors of mine had taken corporate jobs. I totally agree with that, but in my batch, also in my senior batch, I have seen students, many students, majority of the number of students have not opted for corporate jobs. They are either they're either joining courts, or they're either preparing for judiciary. Many people I know, even people are going for UPSC as well. So I would not agree as of now. If I see the condition now in my college, then majority of the students have not opted for any job. They are preparing for some exams, or they have joined courts. And even my juniors, I have a sibling, I have two cousins who are junior, who were junior in my college in NLU only, but they are also opting for it, or their batchmates are also aspiring to become judicial officers or to join courts. They are also not very much interested in corporate sector.
So you think that situation is changing now?
Yes, so it's changing, and we also do internships and moot courts in our colleges. So I think a shift of balance is happening now.
Okay, fine. So you said that you did not participate in any of the moot court competitions. Any specific reason for that? Because most of the most of the students, especially from the NLUs, they are like
Yes.
interested in these advocacy or ADR concept, ADR kind of competitions and even moot courts. So, any specific reason why you did not, represent your college in any national level or state level moot court?
No, so there's no specific reason. I was never interested. I never showed any interest in that particular area. Although I have done some MUNs, which is Model United Nations. I have done
Mhm.
two MUNs, only participated, and that did not attract me much. So I did not do it. And also in our college, as moot court competitions, I like in intra college moot court competitions were common. So we used to participate in that, but I have not represented my college in any moot court competition. There's no specific reason. It's just that I uh, never was interested in that.
Okay. So, will it be correct to say that you are kind of like the, always into the books, the bookworm kind of student? Or do you have anything to prove me wrong that, like, in co-curricular or extracurricular activities also you have participated?
So I did not participate in a competition, but yes, I had. I was, in our college, there was the campus had so many sports facilities, such as we had badminton court, we had volleyball court, we had basketball court. So I used to play, I used to run, I was into gymming and all, but I used to work out every day. So I was interested in those things, and I used to watch movies and all those, but I never represented my college in any level, either in sports or mood court or anything.
Okay, okay, fine. So, your knowledge in IPR, okay, because that was your special paper. So, if you're selected in Odisha Judicial Service, how will that knowledge of IPR help you in Odisha Judicial Service?
Um, one of the reasons because I took IPR as my honors was IPR is a booming industry as of now. We are seeing multiple cases of copyright infringement, multiple cases of patent infringement every day, and it is growing every day. It is one of the most booming industry in our country as of now. So my knowledge in IPR will definitely help me or give me an edge in those kinds of cases. So
Okay, let me, since you have studied that, so let me say that, there is a, let's say OJS exam, OJS prelims questions. Okay. So what I have done is
yes,
I have compiled a book. Okay. Taking last 5 years OJS questions, preliminary questions, along with the detailed solutions, whatever, etc. Okay. Now let's say
okay,
the OPSC, is filing a case against me that I have infringed their copyright. That these questions were basically the property of OPSC. Okay, and without taking the permission, I've
yes.
used the questions and I have given the answers and all. Okay, and it comes to your court. Okay, what judgment will you give in that case?
Actually, I started it around 2 years back. It's been so many years that not so many years, but 2 3 years have been passed. So I don't exactly remember, but whatever little I remember, I can say that infringement. This won't be an infringement of copyright because there are certain spaces, there are certain kinds of ideas that is common to everyone. For example, the source of the question is same. One cannot expect any other person to altogether discover or altogether make a different question out of something. If there is a concept, if there is limited concept, then questions will be same. Questions are bound to be common, questions are bound to be same. Suppose an example is there are so many movies or there are so many TV shows in which they show the girl to be coming from a poor family and the boy to be coming from a rich family, and they fall in love and they fight against the society and they get married. This is an idea which is common to the whole world. This is now a repeated idea. So if someone makes a movie out of it, the first person who made a movie on this concept can't sue the other person on the copyright infringement, because this is an idea which can come to any person. And this, in this scenario, this is a small we have bare acts, we have concept which is very limited. Law is not something which is see, or it's not something which is everything under the sky or everything under the sun. So the as the source is limited, the questions are bound to be common, bound to be the same. So I don't think this will be a copyright infringement. So
Okay, fine. So now, can you tell me in IPC which section deals with misappropriation and what is the concept of misappropriation?
Misappropriation of property is an offense under Chapter 17, as it is an offense against property. And this falls under Section 403 of the Indian Penal Code. Any property of any other person is criminally misappropriated for the use of that person, for the use of the accused, then in that case it amounts to misappropriation of property.
Mhm. Okay. So suppose a person has actually received stolen property. Okay. So someone has actually stolen, Mr. A has stolen some property and he has given it to Mr. B. He
Okay.
owed some money, okay, to Mr. B. Instead of the money, in lieu of the money, he gave him that stolen property. B does not know it is a stolen property or whatever. He has kept it. Under IPC,
Okay.
is Mr. B, has he committed a crime? If he has, then under which section that will be covered of IPC?
So B has not committed any crime because even though he received a stolen property, he did not know that the property is stolen, or did not have any knowledge or idea that this might be a stolen property. So I don't think B has committed any offense under any of the offenses under section any of the offenses under IPC.
Hmm. Okay, right. So tell me under IPC, which sections deal with criminal force and assault?
So, criminal force and assault are dealt under section 450, 350 and 351 respectively of the Indian Penal Code. and criminal force is a force, as force is something which is when a person applies to other, he applies that with the intention that his movement may be seized or his movement may be changed or anything. So when he applies that force with the intention of causing annoyance or hurt or to commit any offense without the person's consent, then in that case it amounts to criminal force. And when the person is not actually has not actually applied criminal force, but he's about to apply the criminal force, he makes any gesture, he conducts himself in a way that the other person gets the apprehension that the other person might commit criminal offense against him, then in that case it amounts to assault.
Okay. Let's say Mr. A and Mr. B, they have suddenly started the fighting, on a public road. In that case, what all sections can be imposed against them in the IPC?
So, if two persons are fighting in a public place and they are disturbing the public peace, then the offense of affray has been committed. It falls under section 159. So, and affray states that when two persons, by fighting or by doing any act, they breach the public peace, then the offense of affray is committed. So, they have committed affray. So.
Okay. How is that different from rioting? Can you tell me, like, what are the ingredients of rioting?
So, writing is basically an offense which has been defined under Section 146 of the Act. And writing requires five or more persons forming an unlawful assembly. So, when five or more persons form an unlawful assembly, according to Section 141 of the Indian Penal Code, and while doing that, while trying to achieve the common object as laid down under Section 141, such as to overawe the government, to prevent any person from legally doing what he is bound to do or what he wants to do, or to commit any kind of mischief, all those acts which are laid down under Section 141. While doing that, when they use criminal force or violence, then in that case, the offense of unlawful assembly turns out to be the offense of riot. And riot and affray are different in the way that riot requires at least five or more persons to commit that offense, whereas affray requires two or more persons. And again, the main thing that the main thing or the main essential under riot is they are trying to achieve a common object, while in affray they are just fighting with each other and disturbing the public peace. So, and again, the difference is that lies in the punishment for both of.
Okay, fine. So you have studied the various theories of punishment based on which the entire, penal provisions are there. Can you tell me what are the major theories
Yes.
of punishment? And if you see IPC, I mean, that is what, I mean, it would go under which of these theories?
Yes, sir. There are total five kinds of theories or under for punishment under Indian Penal Code. One is deterrence theory. Another is preventive theory. The third is retributive theory. Fourth is reformative theory, and the last is compensatory theory. So every theory has a different object to achieve. For example, in deterrence theory, they believe to inflict a punishment so severe that will set an example before the society, and it will deter the society members to commit such a kind of offense. Second is retributive theory. In retributive theory, the main object of this theory is to eliminate the offender itself, eliminate the offender from the society. The third theory is So retributive theory actually lays down the principle that an eye for an eye makes the whole world right. So retributive theory is what the offender has done, do that to the offender, the same thing to the offender. Then preventive theory is what I said about retributive theory. Preventive theory is to prevent the criminal or to eliminate the criminal from the society. Then reformative theory aims at reforming the offender by teaching him good values, education, everything. And compensatory theory believes that compensation makes everything right. So if we see our Indian Penal Code, then sir, I wouldn't say, I can't place Indian Penal Code or the theory of punishment under our criminal manual in any one single theory. It is a mix. It is a mix and match of every theory. It's a bag of borrowings that we borrow from every kind of theory that is there under IPC. So I can't just place it under one single theory. So
Okay, so but out of these five, which one do you think is the most effective theory of punishment, which is backed by empirical data?
um, so the least one I can think about is retributive theory. It is the least effective, and the
Okay.
most effective. So I so I don't know about the data, which what the data show, but according to me, so every country has a different kind of environment, and for every country there should be a different kind of punishment. For example, if we see developed countries, in those countries, reformative theory may be the best kind of theory. For example, developed countries such as Switzerland or Sweden, in those countries where people have more literacy rate and all those things. So in that case, reformative theory may be better for those countries. But a country like India, or if we take the example of Bangladesh or Pakistan, in these kinds of countries, I think more severe punishment or reformative theory won't work. So it depends from one country to one country and from one society to one society, I think.
Mm-hmm. Okay. So, can you tell me what are the two types of successions? Okay, that we generally see in the Hindu Succession Act. Two types of succession.
Uh, so the two types of succession that we see under Hindu Succession Act is, one is testamentary succession, and the other is succession. So actually, I think there are three kinds of succession. There is one testamentary succession. The other is succession by survivorship, which has now been abolished or repealed. That does not apply anymore. And succession, the rules of succession that are laid on under the Hindu Succession Act, interstate succession rules. So
Okay, interstate succession rules. Okay, fine. So, in your syllabus, there was only, I guess, Hindu law and Muslim law, right? Christian law and those things
yes, sir.
were not there. Okay, fine. So, coming to a general concept of personal law. Okay, so there has been a long standing demand by several quarters that personal laws should be more uniform, or uniform civil code should be implemented. Okay, it's also given in the constitution in article 44. Now suppose tomorrow government and Supreme Court has also many times said that it should be implemented. Now tomorrow suppose government implements uniform civil code in India. What will be your how will you see it? Should the government impose or force it, or should they try for a consensus, because consensus would be very difficult? Okay, at one point of time, if they realize that there's no chance of consensus, so they'll go ahead and impose it. What is your opinion? Should it be imposed on the population, or should we respect diversity and we should allow separate laws for separate religion, personal laws?
So, as it was laid down in our constitution when the constitution was being drafted,
Hmm.
the lawmakers had at least thought of it being implemented in next 10 to 20 to 30 years. But due to several factors such as intolerance, as we see, is increasing day by day between different communities and everything, so it will become difficult day by day to apply for the government to even think to apply uniform civil code. And speaking of forcefully applying it, I don't think a law should be forcefully applied on any person, because especially in India, where religion is a very important thing for people belonging to that certain religion. So I don't think it should be forced. But first, I think people should be aware, people should be educated, and people should be made more liberal towards each other. They should start respecting others religion. And first, I think this harmonious environment should be achieved. People should try to achieve this kind of environment, because we see that the politicians also sometimes play dirty games, and they try to gain vote by communal disparity between each community. So I think first of all there should be an awareness, there should be a harmony between communities, then only we will be able to achieve the state when we can get a consensus. So although even if we bring uniform civil code, it won't infringe the right of people, because it's not violating article 25 of any person. But imposing will be, I think, a bit extreme. First we should educate the society, first we should get the society aware, then only I think it should be brought, and it should be brought with consensus, because religion is very close to every person, I think, in India.
Mhm. There is a long-standing proposal on a kind of like for the administrative service, there is a Indian administrative service. Similarly, for high courts and even for Supreme Court, there should be a Indian judicial service. Okay, where through a competitive exam, uh, people will be selected to become judges in high courts and Supreme Court. What is your opinion, which has been strongly protested and strongly it has been held back by the various bar associations of India and even the Bar Council of India? What is your opinion?
So, I actually haven't studied, or I don't actually know exactly, or it's not crystal clear to me that what will be the kind of exams, or how the whole process will work. But as of now, the judges of the High Court and the Honorable Supreme Court are selected by the, or through the collegium system. So as of now, I do not see any problem with the collegium system, or I don't think there's any problem with that, because judges will know judges more, and they will able to see, or able to calculate as to, or able to judge that which judges should be elevated in the Honorable Supreme Court or the High Court. So as of now, I don't see any problem with the collegium system. So I don't know exactly how this All India Judiciary will work. So I don't know, so.
Okay, you're saying that the collegium system works well. Doesn't it, like many critics propose or say that it gives a chance for nepotism, and no one really knows how they are selected. There is no, clear guidelines. The central government tried to bring the NJAC, but it was struck down. So,
Yes.
if three people's name, let's say three advocates name are proposed, okay, and
Yes, sir.
how the chief justice of a high court then selects that, among these three advocates or among these 10 advocates, these two are more suitable, okay, their name should be recommended, because no one really knows why, how, what are the criteria, what is the criteria for it. So that is the
Yes.
reason, since there is opacity is there, it is not transparent. Lot of allegations are there of nepotism and political interference and whatnot. Okay, the problem of uncle judges in many cases. Okay, so
Yes, sir.
grouping, etc. So you said that there is no problem with the collegium system. Uh, can you tell me this, in the collegium system there is the famous three judges case or the four judges case if you add the NJC one? Can you tell me something about the three judges case?
Yes, sir. There was three cases which are famously known as three judges case. In the
Hmm.
first judges case, it was basically the whole point of debate in these three judges case was whether the president of India is bound by the advice given by the collegium or not. So the word or the term which is used under Article 124 that lays down on the consult, or the word consultation was issued. So in the first judge's case, it was decided that the word consultation means advice. It does not mean concurrence. In the second case, it was laid down, it was struck down. The first judge's case was repealed, and it was held that the word consultation means concurrence, and the president of India is bound by the advice of the collegium system, or the collegium that is formed. Now, in the third judge's case, also it was held that the president of India is bound by the advice of the honorable judges of the Supreme Court, and also the limit was extended to five. There will be five judges who will form the collegium in the including the Honorable Chief Justice of India. So this was about the three judges case, and the fourth judges case, if we add, was in the year 2015 when NJAC was proposed, and it was declared ultra vires, or it was declared unconstitutional. So my opinion in this case is, first of all, the constitution of NJAC, which was there, it also included, although it included the judges from the Honorable Supreme Court, but it also included certain other persons. For example, one from politics, one from legislature, the law minister of India, and other politicians also it included. So the whole structure of that NJAC uh, was was in question, because if we see the structure of NJAC, then any person can persuade the other person, or any person can persuade the person or the members forming that NJAC committee, and they may get selected. It will lead to biasness. So I would like to give an example of United States of America. In that case, in that country also, the judges are selected by a similar body, which in India it was formed NJAC. They have also a similar kind of body. So in the year 2015 or 16, I think, Donald Trump advised, or he selected or elected somebody, some lawyer who had the similar idea as Donald Trump's party. So the decision was heavily criticized because it was seen as it was being biased. So NJAC also, if we form, as India is not unknown to corruption and everything, so it might lead to those things. It might open the can of worms. But if we see collegium system, although collegium system has also its flaws, like you said, it is opaque. It's not that transparent. It should be transparent. We don't know what happens inside the collegium system. But I'm saying that every whatever options are available in our country as of now, collegium system is the best suited system to elevate judges or to select the judges. As of now, there is no other option which can replace collegium system. Although there can be some improvements, such as transparency can be brought, such as the honorable judges might let the outer world know what are their criteria, what are their guidelines to elevate a judge. Transparency can be brought, but as of now, I would say there is no other system that can replace collegium. There is no other system which is better than collegium as of now in our country.
Mhm. Okay, what do you mean by res ipsa loquitur?
Uh, so the phrase res ipsa loquitur means the thing speaks for itself.
Mhm. And what is sui generis?
So I don't remember. I have heard this, but I don't remember.
Okay, fine. So, going to the constitution, so directive principles of state policies. Can you tell me those directive principles which can supersede the fundamental rights? Is there any directive principle which can supersede the fundamental rights? If yes, then what is the directive principle? And if you can tell me the articles.
So I don't know.
Okay, have you heard the term when Article 31C comes in, Article 14 goes out? Have you heard this phrase?
No, sir.
Okay, what is there in Article 31 A, B, and C?
Uh, so I don't remember.
Yeah, these are exceptions, right? To it's like to the fundamental rights. Article 31 as such is repealed, but 31 ABC is there, right? Okay.
Yes.
In which article of the Constitution the fundamental rights of the armed forces and intelligence agencies, etc., are curtailed? For example, my uh, freedom of speech and expression under Article 19, and your freedom of speech and expression under Article 19 is not the same as regards to a army major. I mean, we can write anything and everything on Facebook, but he cannot, right? So there's a particular article within part 3, which gives that. Can you tell me which is that?
So let me may I repeat the question, sir?
Yeah, basically, I'm asking one particular article under part 3 of the constitution, under fundamental rights. Okay, it limits the, okay, rights of the defense personnel, intelligent people working in the intelligence agencies, paramilitary forces, etc. You need to tell me which article does that. Is it 33, 34, or 35?
So okay, so it is one of the three.
Yeah, it is one of the three. 33, 34, or
So I
35.
don't know.
Okay, see, 12 to
Okay, so
35
I
should
don't.
be very clear to you. Okay, 12 to 35, maybe it has
Yes.
to be just on your fingertips. Okay, that's part 3 only. Okay,
So I
uh,
only read until 32. I'll read the rest three.
yeah, because generally all the rights are contained between 14 and 32. So most people will go
Hmm.
through 14 and 32, right? So that is the thing. That
Yes, sir.
okay. Um, so our right of a person, okay, against bar fetters, right? That is there in which article? You know
So
what?
I'm sorry, I could not
Do you know
understand the
what you
question.
mean? What you mean by bar fetters? The
No, sir.
medieval kind of equipment which basically binds a person, okay, who is to be punished by the king or someone. Okay, just like we have handcuffs now, kind of that kind
Yes.
of thing. Okay, so which article in part 3 basically gives a person freedom from that, right against bar fetters?
So Article 22.
Yeah, it's 22 or 21.
So
Harish?
22.
22. Okay, just
So
go to.
21. I'm sorry, sir. 21.
Okay, that's fine.
21. I think there was a landmark case on this particular thing, I think.
Okay, okay, and let's say that abolishment of titles. Okay, that is given in which article in the constitution?
So Article 18.
Okay, and which kind of titles are these? Let's say people use major general or lieutenant commander or squadron leader. Is that wrong? Because that is also kind of title. Which all titles are banned, or which are titles, okay, cannot be used, and which are the titles which can be used?
So the titles that can be used is, for example, academics title can be used,
Yeah.
and any other title which has been given by any person who or any country apart from India, from outside the country, then with the permission of the president of our country,
Hmm.
the other person can use those articles if the person is a resident of the other country.
Hmm.
And what all articles one can use is, I am not able to recall.
Okay, let's say someone has been awarded Bharat Ratna. Okay, now that person,
Yes.
or Padma awards. Okay, now that person uses the, like, Mr. X. So Padma Bhushan Mr. X, he's going on using that as a title. Can you tell me
Yes.
any judgment of the Supreme Court on this, that can it be used as a title or it can't be used as a title? Yeah.
So I don't know.
Yeah, it can't be used as a title, and if it is used as a title, maybe government can take it back. Okay, right. Okay, that's fine. So uh, right to property was initially there in your what is that, your article
Fundamental.
9, fundamental rights, article 19.7, freedoms you had. Now what is its position? Is it a constitutional right? Is it a legal right? Or what has happened to this right to property? Is it there in the constitution now, right to property?
Yes, sir. Yes,
Where?
sir. So
Where?
right to property is there in the Constitution. It's under Article 300A,
Hmm.
and it was repealed as a fundamental right by the 42nd Amendment. and it was added as, or it was made as a constitutional right under Article 300A. So the position of a right to property is that it's a constitutional right, or it's a legal right. It's not a fundamental right.
Do you remember the preamble of the Constitution by heart?
Yes, sir.
Okay, so just tell me in the last
So
line, what is the no need of
yes.
telling the entire thing. What is the date which has been mentioned with the people of India
So
solemnly approved?
26 November.
26
26
November
November, sir.
19
Yes, sir. 1949, sir.
1949. Okay, right. So why did we wait for 2 more months to actually commence our constitution, or the day in which it was fully implemented? Can you tell me the reason?
No, sir. I don't know the reason.
Okay. Okay. When you open the constitution, which part of the constitution comes first?
So basically, so first the preamble comes up, and then
Yes, that's
chapter
fine.
one starts.
Yes, that's fine. So the preamble has been written first, that means, right?
Yes, sir.
Preamble actually has been written last. Okay, first everything else was
Okay.
done. Preamble was drafted last.
Okay.
Okay, fine. And okay, that much for constitution. Now coming to some other statutes, let us come to your law of evidence. Okay, so let's say, uh, you know uh, what are the fundamental principles which the court has to see, okay, in order to admit the evidence, okay, the rules of admissibility of any evidence under Indian law, Indian courts.
So the rules of evidence that the courts need to follow for admitting any evidence, or admitting any evidence, are basically, it should be relevant. First of all, it should be relevant. That means that it should fall under section 5 to section 65, section 55 of the Indian Evidence Act. It should be made relevant, or it should be relevant in any way. For example, it should form part of the same transaction, or it is a expert opinion, or it is something which is dying declaration. So anyway, if it falls under these sections, then it is relevant. First of all, the relevancy has to be seen. Then after that, it should be seen that whether it is admissible or not. For example, whether it's barred by any other section of the Indian Evidence Act or not. For example, if it is a communication between two married persons, a lawfully wedded husband and wife, then it will bar the admissibility of the particular offense. So first of all, it should be seen that whether it is any way relevant to the case before it or not, and then after that, the court should see that whether it can be admitted or not, whether it is barred by any other sections of the Indian Evidence Act or not.
Mhm. Okay. So, what is the meaning of privileged communication, and can you give me at least two or three examples of privileged communication and the sections in which they are dealt in the Evidence Act?
Um, So privileged communication is a communication between two persons which cannot be given as a piece of evidence in the court, or which cannot be compelled by the court to give as a piece of evidence before it. So this is a communication which is privileged. And speaking of examples, first example would be communication that is done between a husband and a wife, which is protected under section 122 of the Indian Evidence Act. It states that when two persons are legally wedded, and any communication that is made between them during the continuance of their marriage cannot be compelled to be made or given as a piece of evidence before the court, unless and until there is a suit, or there is a proceeding that is going on between them where they both are parties against each other. Then in that case, it can be given. Second example could be Second example could be official communication that is made between officers, which if given as a piece of evidence, would hamper the public peace, or it would hamper the public justice. In those communications are also protected under section 123, that is known as official communication. Then under section 126, the attorney client privilege, as we know, applies, and the communication made between an advocate and his client with respect to any offense that the accused has committed or the client has committed, or any advice that the advocate gives to his client. Those kinds of communications are also not admissible, and it falls under the privileged communication.
Okay, fine. So that will be the end of the interview. Um, Thank you. If I had to give you marks, then it will be around 60 to 65. Okay, that is, you're doing quite well, and I expect you to get a good rank, depending on whatever you have done in your mains exam. Okay, so yeah, I'll just stop the recording. If you have any